Good evening, everybody. I'm Michael Tabman. Welcome to Crimes and Times. Tonight, we want to stay with the current news, and there's not much bigger news right now than that of the FBI executing search warrants at locations belonging to the attorney of our sitting president, and that would be Attorney Michael Cohen. It's created a lot of news because it is unusual to execute search warrants of an attorney. It's not unheard of. It's not unprecedented. Attorneys are not exempt from criminal investigations, but it's unusual, and they have certain protections based on the attorney-client privilege. And of course, the fact that he is the attorney of a sitting president makes it all that much more interesting and newsworthy. So I want to kind of go over some of the facts about search warrants, what goes into them. We've kind of discussed them in other shows, but I want to get more in depth and discuss them now and how it relates to what's happening now, the attorney-client privilege, and other aspects of a search warrant. We all know that we have protections against unreasonable search and seizures. That's not all searches and seizures, just unreasonable ones. Often we do it with a warrant, but there could be exceptions that I'm going to talk about, such as exigent circumstances and other exceptions. But generally, we think about the warrant where you hear the banging on the door, you hear police, FBI, we have a search warrant. And we do that understanding the intrusive nature of coming into somebody's home or office. We give notice. We give knock and notice. And we do that, again, not to give people the opportunity to destroy evidence or to fight back, but just so we don't catch them off guard, by surprise. Again, trying to limit the amount of intrusiveness that we're doing there in executing the search warrant. These search warrants, I understand, were done no knock. And we've heard of that before during the course of the special counsel's investigation. A no-knock warrant has to occur with the approval of a judge. We have to explain to the judge why we want to go in there without giving notice. That would be either for our own safety. We used them often when I was working narcotics in New York. We didn't want to give a chance for anyone to fight back, or if evidence is going to be destroyed. Certainly with narcotics, the old flushing the toilet when you knock on the door, say search warrant. But in white-collar crime cases as well, if we believe that the parties inside the location are going to destroy the documents, we have some evidence to back that up, then it will be granted a no-knock warrant. But again, it has to come with the approval of a judge. So please understand that right away. It wasn't done with the discretion of just one FBI agent. It was done with the approval of the chain of command, the hierarchy, and ultimately the judge or magistrate who signs off on the warrant. So let's start with the process. An agent has information. Information can come in many forms. It could be from general investigation, from doing surveillance, from something an informant tells him, or in this case, it's information from referral from the special prosecutor. That's not unusual. We get referrals from other agencies all the time, and we get to use that as probable cause for a search warrant. If it's good information, if it's reliable, in this case, we think we could prove that easily with a special prosecutor, and then we write up an affidavit. So, for example, if I'm working narcotics or even white collar, I use these in white collar, someone inside someone's office or someone's facility says that they have been falsifying records, handing in false claims to the government, just as an example. We'd ask someone how they know about it. Can they bring any proof of it? Maybe they'll slip out one document to show proof of it. Maybe they'll take pictures of something. But we want to verify that the person knows what they're talking about, is being honest, and actually is in a position to know what they say they know. And we have to build a case of probable cause. Now, please understand that probable cause, again, is not absolute certainty. It just means something is more probable than not. And that's based on many factors. And one goes to the credibility of the source of the information, whether we believe them, whether they've given us information in the past that's been reliable, and who they are. So, for example, information from an informant may be very reliable. It might be someone who's given us information before, and it might be someone who's trying to retaliate against somebody. Motivation is important to determining their credibility, but it does not mean that they are not credible. So an informant gives us information, and that will have some credibility. But let's say we have other information from an undercover police officer. Clearly, by the nature of them being an undercover officer, that will have a higher degree of credibility. We could base more trust on that, what he or she says, based on their experience, based on what they've done, if they were observed, if they were taped. So a lot of information goes into building probable cause. So probable cause are all the facts in toto of what we know and the evidence we have. And I want to go back again to motivation, because this came up during the question about FISA and whether or not the dossier was used to obtain the FISA on the Russia investigation, and whether that's even valid or legitimate. It is. We use information given to us by people who have ulterior motives, whether it's another criminal trying to protect himself. He thinks he's about to get killed. We see it in the mob. Whether it's another drug trafficker trying to knock out the competition or get revenge on somebody. Somebody could be doing it for their own purposes. By doing it, I mean providing us information. Doesn't mean the information is not credible. Now, of course, we have to look at their motivation and report it, that this is an informant, and maybe why we know he's giving this information. But it doesn't make that information invalid or inadmissible in terms of building probable cause. If it's good information that we think has a high chance of being correct and being accurate, we can use it. Of course, as was said during the hearings or the disputes about the dossier, should that be revealed to the judge? Of course it should be. But again, the fact that it's coming from somebody, opposition research, doesn't mean that it can't be used or that it's not accurate. And remember, we actually did a show here on Oppo Research a while back. And Oppo Research, though they're trying to dig up dirt on their adversary, it doesn't mean that they're making it up, because they're trying to give up dirt that will work to discredit that person. If you just want to make it up, you don't need Oppo Research. You just make it up and you smear somebody, do whatever you want. But Oppo Research, they're actually looking for real information, true information that can be used to discredit the opponent. So the fact that we're getting it from Oppo Research doesn't mean it's not legitimate information. The fact that we're getting it from an informant, a bad guy, or someone who may be engaged in criminal conduct doesn't mean it's wrong or it's bad. We just have to weigh that against all the facts. Excuse me. So we get this information, and here this was information referred by the special prosecutor. We don't know how the special prosecutor got that, whether it was through other searches, testimony of people who are cooperating with him, or whatever. But clearly, the special prosecutor felt that this was outside the scope of what he was doing and properly referred it to the FBI. There's nothing wrong with that. We are constantly referring information to other agencies based on jurisdiction, based on having other cases, and interest in that case. That's completely appropriate and proper. So an agent gets this information, and he or she, I'm going to say he for simplicity, starts building probable cause, starts writing out the facts. I was told this. I have this document. And within that is a certain amount of boilerplate. The agent talks about himself, his experience, his training, to give him credibility as the affiant on the search warrant. But then we have to lay out a very, very detailed document as to the probable cause, as to why we have probable cause to go searching for something. And when we used to run citizens academies when I was the FBI, they still do it. When I was doing it, we often would show them copies of affidavits for search warrants. And they were usually pretty surprised. They would think, oh, you didn't just fill out a form? No, we don't just fill out a form. Very, very detailed. And then what are the details about? It's not just, I want you to find this, or I think this object is here. We have to be very, very specific. One, what we are looking for. It can't just be general evidence of the crime. I am looking for this document that says this, or this document from this person with this date on it, addressed to this person. Something very specific. It could be records. I am looking for records related to these transactions or these transcripts. Something like that. It has to be specific. It just can't be a fishing expedition. And we've discussed that. You just can't go in and say, I'm looking for stuff. You have to say what you're looking for. Then you have to give the reason why you think it is in that location. So, for example, narcotics, we would say, well, we saw the person conducting these transactions out of his house. Here it is on tape. We have informants. We observed it ourselves. We saw activity that was indicative of drug trafficking, and we know from our experience, based on years and years of watching drug traffickers, this is how they operate. And I'm going to use a specific example in a moment, on how that works. Then we have to say why we think it's in that location. So what we're looking for, why we think it's there, and why we think it'll be there now. So that's also specific. So if an informant comes to us 6 months after a fact and says, I saw that document, I saw that gun in the guy's house, we're going to have a hard time getting a search warrant saying, well, someone saw it 6 months ago. Why would we think it's still there? We might have to send the informant back to look. We might have to try to get some incriminating statements from the person. Say, yeah, that gun's still there. Have the informant engage in a conversation. But we have to be specific as to why we think it's there. And then we have to be very specific as to where we're searching. What house, what office, by address, by description, what rooms, what locations. And we have to only look reasonably where we could find that evidence. So, for example, if I'm looking for a stolen television set, for example, I go into someone's house, I cannot search in their drawers because it's not reasonable that I would find it there. And if I did that and I went in the drawers and I found some other incriminating evidence, that would be squashed. The evidence would be suppressed. Fruits of the poisonous tree. Now, there's exceptions to that like everything else. If we go and arrest somebody, we could do what we call a wingspan search. The wingspan doctrine means we could search the immediate vicinity of the person's wingspan, where he could have reached for something, generally for our own safety, looking for weapons. And if we do find something then based on our wingspan doctrine, that would be acceptable. So there's a lot of exceptions to all these rules, and they apply based on the circumstances. So when we got this search warrant, we being the government, when they got the search warrant, for Michael Cohen's records, I assume they were records, whatever else they were, there was specific information as to why they should go in there without knocking and announcing, probably the destruction of evidence. I don't think it was a safety issue. Why the documents were there now, that would be based on some current information, what these documents were, and how they related to criminal activity. So I want to be specific about something. Excuse me while I just look at some documents here. When we go looking or we apply for a search warrant, the statutes are very specific. We may apply for a search warrant, and a warrant may be issued for any of the following: evidence of a crime, contraband, fruits of the crime, or other items illegally possessed, property designated for use, intended for use, or used in the committing of a crime, or a person to be arrested or a person who is unlawfully restrained. So we're using a search warrant to go after somebody. Obviously, if we feel someone's being held against their will in a house, obviously we believe they're there at the moment, we have reason to believe they're in danger, we go in there and rescue the person. But if we don't have that kind of information, we get a search warrant, we go in there, rescue someone, or go in there after someone that we think is hiding out there. But more specifically for this evidence, that's the criteria. So something may not be illegal of itself, but if it's used in the commission of a crime, such as, let's say, a printer, high-resolution printer. The printer may not be illegal, but if it's using to make counterfeit money or something else counterfeit, it's evidence of the crime, and we might be able to show that that printer was used to produce these illegal documents. So those are the kind of things we're looking for. So it doesn't have to be the evidence itself. So we talk about specificity. Let's talk again about the probable cause, because I think there's something very important here. A case I often talk about, I even refer to it fictitiously in my novel Bad Intent, was a case whereby when I was working narcotics, we had information that someone was a drug dealer. That information came from another undercover operation that we had going on. We couldn't expose that operation, so I couldn't use that information specifically to get a search warrant or a wiretap, because I wasn't willing to reveal that, though that could be a source of confidential information. That undercover operation could be a source. Excuse me. But I took the information about this, and I and the team, we did a surveillance of this person based on that information. We don't need any real substantiation of the information to do a surveillance. It's not like doing a wiretap. It's not considered that intrusive. We're just following him around. And these were the days of pagers, not long before cell phones, but before cell phones. And we followed this individual around for a couple of weeks and saw nothing. Nothing criminal. He would drive around, he would visit buildings, he'd get a pager, go to a cell phone. We didn't see any transaction. We did see him meet with certain people under unusual circumstances, meeting at locations, leaving in separate ways, things like that. That is, in the opinion of an experienced agent, that's indicative of possibly drug trafficking. It's not conclusive, and probably not even enough at that moment to get a search warrant for anywhere in particular. So we did more searching, and we found that he owned some of these buildings. Well, you have that kind of money to own buildings and you're not working during the day. We see him going somewhere, engaging in what we think is drug trafficking activity. You have money you can't account for. Again, we're building up a probable cause. Then it all culminated one day when our surveillance unit followed this guy to an airport, and he met two people flying in from Miami, and these people got off the plane and they went in separate directions. They had briefcases with them. They put the briefcases down two other people picked up the briefcases, walked in separate directions, and met outside the airport, then got into cars, drove out, and then went in separate directions. Nothing about that is illegal. Nothing about meeting people at the airport, switching suitcases, and then going in separate directions, meeting somewhere else and going in separate directions. That's all legal. So what happened? We followed them. Well, it was amazing that we got them. The surveillance, this was in LaGuardia Airport on rush hour traffic in the rain. The surveillance unit called us, said, hey, we got them on the surveillance. There's two cars. I called them, said, you follow one car. We'll try to find the other one. And amazingly, we found the other car coming out of LaGuardia Airport. We couldn't believe it. Anyway, we followed them for a while, and when we felt we were going to lose them, we pulled them over. And I did a search of the car. It so happens we did get permission to search the car, but we knew that they would argue they never gave the permission, even though we had them sign something, and it'd be quashed. But there was also another exception to a search called the Carroll Doctrine. You have less expectation of privacy in the car. So they opened the trunk, and there were two suitcases in there, and I opened them up. They had a little tiny lock on them. I was able to just break the lock, with a little twist of my hand. And in there we found, I think, over 60 kilos of cocaine. A pretty big haul. And from that, we were able to use that as probable cause to get a search warrant on a place. The rest of the team followed the other car, where we found another 30 or 40 kilos of cocaine. We found weapons. We found some fugitives, and we found explosives. And it's a pretty big haul for the day. But when we got to court, needless to say, the individuals in the car moved to quash the search of the car, saying it was an unconstitutional search. They did not give their permission. We knew that would happen. We argued that, of course, under the Carroll Doctrine, we had the permission to search the car. Now, what the defense attorney kept asking me, said, Agent Tabman, is there anything illegal about going to an airport? Agent Tabman, is there anything illegal about picking up a suitcase? Agent Tabman, is there anything illegal about this? Blah, blah, blah. Went on and on. And my answer was no. There was nothing illegal about it. To get to the heart of the story here, the judge took it under advisement, and he came out with his ruling, and he stated that under the circumstances, given my experience and the collective experience of my squad mates, we could have drawn no other conclusion than it was drug trafficking and there were drugs in that car. The fact that we were right isn't really what solidified the probable cause, because even if we were wrong, we would have to justify it, and the judge said, yes, you had probable cause based on all the facts in toto. So what I'm trying to highlight here is that probable cause doesn't necessarily require something illegal to have occurred in front of an agent or the detective or the investigator. It's the totality of circumstances. All right? So I hope we clarified that. Now, when you do a search, as we talked about, a search has to be reasonable. And not every search will be deemed reasonable. I want to talk about one case here, even with the search warrant. Here in the case Winston versus Lee, I'm just going to read from this article. The Supreme Court held that performing a court-ordered surgery on a suspect in order to remove a bullet from his chest would violate the suspect's Fourth Amendment rights. The court reasoned that a compelled surgical intrusion into an individual's body for evidence implicates expectations of privacy and security of such magnitude that the intrusion may be unreasonable, even if it's likely to produce evidence of the crime. So here the court's saying, yeah, we believe that. We think you will find evidence of the crime. But they are focusing on the reasonableness of it and saying forcing someone into surgery to get a bullet out of his chest is just too unreasonable, even though there's evidence of the crime. So the courts really do put a very significant test to that kind of intrusion, searching. Remember, we want to be secure in our papers and our documents, our homes, per the Constitution. So there's a lot of controls there on that. Excuse me, I just put up a little note here. Something I want to remember to say, and that's what this is now. As I said in my statement about my search of the car, we didn't necessarily have to be right in that we found it. We just had to be right that it was probable cause. So many people coming out now and saying, wait, whoa, whoa, this doesn't mean anything. The FBI has been wrong before. They could be wrong. Yes, that is true. The FBI has been wrong, and they can be wrong here. Remember, we're only saying, or when I say we, I mean the government. I keep putting myself back in that mode. I'm not there anymore. The government's only saying we have probable cause to believe that there's evidence of a crime's been committed, the stipulations I read earlier. and the judge is saying, yes, there's probable cause. No one is being convicted based on the existence of a search warrant. They may be convicted based on the evidence found from the search warrant, but the search warrant itself is not a prosecutorial document. It's authority to be intrusive. Yes, we understand that, and that's why we set a bar. But you're not going to be convicted just on the fact that you were searched, maybe the evidence. So please keep that in mind. So no one's saying anybody's guilty. We're just saying, or all that's being saying, is there's probable cause of a crime here. Now, how strong do we think this probable cause is? Probable cause is probable cause, right? Kind of. Now let's get into the attorney-client privilege. The fact that it is his attorney, or the president's attorney, there is an attorney-client privilege. So if I am talking to my attorney, I just committed a crime and we're getting ready for my defense, I said, yes, I robbed a bank, and I give him everything, that is a privileged communication. And there's a reason why we have that. And let me just go back to another document here. The attorney-client privilege is to accomplish two things. One is to allow the person to have a defense. If they couldn't trust that what they say their attorney would be confidential, well, how are you going to have a defense? How do you tell your attorney everything? You would lie to your attorney, you would leave out information, and you wouldn't get a solid defense. And that's what the Constitution guarantees you, right? The best defense possible, realistically, reasonable. And so you need that. And also, if you were to tell your attorney, if you told your attorney something, and he was allowed to go and tell the police communication, that would be a violation of your self-incrimination, because you're going to the attorney for your protections, and he's releasing that, and that would be what's believed to be a self-incrimination violation based on some other articles I read here. So twofold, but primarily is to give you a good chance at a strong defense. Give you a chance for a strong defense. That's the reason for the attorney-client privilege. But the attorney-client privilege is not absolute, as very few things in this world are. So you can waive your attorney-client privilege. You can do it knowingly, say I'm waiving it for whatever reason. Maybe you want to let your attorney testify to something, whatever reason. Or you can do it negligently, or not even intending to do so. What would be an example of that? An example of waiving the attorney-client privilege would be, I am now having a conversation with my attorney here about my case. There's a third party. Maybe I'm sitting here on tape doing it, and I'm discussing my strategy, and I'm letting you in on my strategy. I've just waived my attorney-client privilege. It is not my attorney and I'm sharing this with a third party, not involved in the investigation. So, for example, if the private investigator is there working on the case, other team members, even the attorney staff who are not attorneys, they're part of the team. That's covered under the attorney-client privilege communication. If I work for an attorney now, my firm, Spirit Asset Protection, may do an investigation on behalf of a law firm representing someone else. When we do that, we are operating under the attorney-client privilege. What we provide to them is work product, the attorney. It's privileged communication. So there's an extension there. But if I just share it with somebody else, no, I've given up that privilege. And I can just do that deliberately, have you in there, say, hey, listen to what I'm saying, or I can do it negligently. If I'm on public transportation, I'm talking to my attorney in a loud voice and other people are hearing it, even though I may not intend it, if I'm being negligent, I could be giving up my attorney-client privilege. So it is not absolute. And there are other exceptions to it, but let's get to the one that's more important. This one is, excuse me, here I get my documents out. This is called the crime fraud exception. Under this, basically what they're saying is that you cannot use your attorney-client privilege to commit a crime, meaning your attorney cannot be a party to the crime. So if you're going to use your attorney's position or his power or his facility to commit a crime, that is not privileged. The attorney becomes a party to the crime. And the attorney-client privilege does not extend to everything you do. Let me just read again from somewhere else. If a lawyer is defending you on a certain crime, it does not mean he represents you for every crime. So you can't just run out there, commit a crime the attorney doesn't know about, and say, I got a lawyer, he defends me, and anything I've said to him in the past about anything else, is privileged. It has to be an attorney-client privilege, you have to have an attorney. You have to have engaged in attorney-client privilege. I have to have hired you to be my attorney, an attorney. So if I'm just, again, at a bar having casual conversation with somebody, and later he happens to be an attorney and I missed something I shouldn't have said, I can't say, oh, yeah, he's an attorney. That's a privileged communication. No, he happened to be an attorney, but just because you talk to him doesn't mean you have attorney-client privilege. All right? So please remember that. It's that. So here in Clark versus United States, 1933, the court states, a client who consults an attorney for advice that will serve him in the commission of a fraud will have no help from the law. He must let the truth be told. Another example would be if a lawyer sets up a shell corporation, perfectly legal shell corporation, that could be legal, but for the purpose of fostering a Ponzi scheme, and the lawyer is asked about it, or asked how to secure insurance, but the insurance is then used to collect on insurance fraud, that's not attorney-client privilege. It's not the advice of your attorney. It was to commit a crime. So you don't have cover there. All right, so we have some distinction. I hope I made that clear. It is an exception. The attorney cannot be party to the crime. The attorney cannot be facilitating the crime. The attorney cannot just be sort of some random client privilege. The attorney-client privilege cannot be some random conversation you have with an attorney, and it cannot have occurred with a third party who's not a member of the legal team. So a lot of these attorney-client privileges, people say, oh, no, they can't be searched. They can be searched. Right? Attorneys can be subject to search when they committed a crime or they facilitated a crime, or the attorney-client privilege has been waived or breached somehow. So the fact that Michael Cohen is the president's attorney or anyone's attorney does not mean that he is totally devoid or void of any a liability in terms of being searched. Right? He doesn't have a license to commit a crime, and I'm not saying he did. I am not saying that. Well, again, we only have probable cause. I'm just saying that being the attorney doesn't protect him from a search warrant. He has certain protections, but it's not complete. Again, we're only talking about probable cause. So on the same hand, we can't say, oh, the FBI is wrong, because we don't know that. We don't know what they got. We can't say, I see people on social media saying, oh, they didn't find anything. There's nothing there. You must have an awfully good source if you're saying that. I don't know what was there. I don't know what they found, and I don't know what it's based on. We'll find out. But to say there's nothing there is just as irresponsible to say, yes, this is the death knell for the president of Cohen. We don't know. We don't know what they found. Now, let's talk about it realistically. We said before, probable cause is probable cause. That is true. But having been served as an FBI agent, I can tell you this. When you are talking about getting a search warrant for an attorney, that is sometimes called a sensitive investigative matter, special investigative matter. The Bureau has different terms over the course of its lifetime. It is sensitive. It is going to get a very high level of scrutiny in the FBI and at DOJ because we want to be very careful about the attorney-client privilege. The FBI has a very good record of not having evidence quashed based on a search warrant when they get to court. I can't tell you what those figures are, but just based on my 24 years with the FBI, I can't recall a case where we lost the evidence from a search warrant because we didn't follow probable cause. Our affidavits are very, very detailed. And I can tell you this, I've been working on, as some of you know, wrongful conviction cases locally, as opposed to some of these local affidavits I've seen where they say there's probable cause because I say there's probable cause to believe. That's not probable cause, and I'm surprised those have made it through the state courts. Those are, to me, should absolutely be appealed. But nevertheless, the FBI affidavits and search warrants are very, very detailed. I'd be surprised if this is any different. So they're very detailed. They're going to get a high level of scrutiny because we want to make sure we do not violate the attorney-client privilege. And realistically, because this is the President of the United States, this probably undoubtedly received the very, very highest level of scrutiny before it got out there. And I know you're going to say I'm being anti-Trump again. That's not my intent. But the President's attack upon this process is unwarranted. It is undermining, or at least an attempt to undermine, our system of justice. I know the FBI has its issues. They aren't perfect. I have talked about the mistakes I think they've made. But this whole process now, coming from the special prosecutor getting a search warrant, is not just with rogue FBI agents out there. This is being done very meticulously with a high degree of supervision at different steps. The president should let the investigation play out. If he has nothing to fear, he has nothing to fear. Let it play out. Whatever's found in this search is still going to be subject to trial, to a suppression hearing. Excuse me, I'm just turning my phone off there. To all sorts of judicial scrutiny after the fact. Even if they find evidence, it doesn't mean it's going to be used in court. They can still try to quash it. And in those hearings, if it's found that the probable cause was met, and this was done legally, it will be admitted. We don't know what the evidence is. Now, I understand we've heard words that the president's name was used on these affidavits. We heard they're looking for those Access Hollywood tapes, trying to figure out what the federal interest would be in that. I could only hypothesize, but that'd really be just me guessing at this point. But it is very interesting if those facts are true. Again, this is what's being reported, that the president's name was used, because then either he's the target or he has a significant amount of activity involved in establishing that probable cause. Okay? So it is certainly incriminating at this point. It is not conclusive. Let's wait and see. I'm going to tell you that I think the fact that we got this search warrant on Cohen's different locations, the way they were executed, I'm going to guess that Cohen is in a lot of trouble. I really feel that way. Again, I don't know for sure, but based on my experience as an FBI agent, how we execute search warrants, the scrutiny given to it, the discretion used to go after an attorney who's representing someone, a lot of oversight. This was done very carefully. My guess is it's going to yield a significant amount of evidence. We just don't know. So I just want to recap what we went on here again about search warrants, the level of evidence, the fact that attorney-client privilege is not absolute. Again, an attorney cannot take part in helping you commit a crime, cover up a crime, facilitate a crime. You can waive attorney-client privilege either intentionally or unintentionally by negligence. Just talking to an attorney casually does not give you attorney-client privilege. You actually have to have an attorney hired for the purpose of defending you on that specific crime. So a lot of elements go into that protection, and that the FBI does honor that, understand that, and because it's not absolute, they're able to get a search warrant with the greatest amount of scrutiny. I want to clarify that. I do want to say again, I think it's wrong of the president to attack the process. He's trying to undermine our system of justice. Attorneys are not exempt from the judicial process, and nor should they be, but they should have their protections in defending their clients. If you have any questions, please send them to me at crimesandtimes@gmail.com, crimes and A-N-D spelled out, crimesandtimes@gmail.com. I'll get back to you the best I can. Thank you for watching tonight. I appreciate it. I'm glad to have this chance to explain to you kind of what's been on my mind and some of the misunderstandings I think are out there regarding the search warrants executed on the president's attorney. We'll be back next week. Thank you for all the kind emails I'm getting. We did mention last week that I am running for the governor of Kansas. I will keep trying to do these Crimes and Times as much as I can. My schedule is getting very busy with the appearances and just the nature of a campaign, but I enjoy doing this. I like bringing the information. I like having our guests on. We've had some very interesting guests, and we'll continue to do that. Once again, I'm going to ask you, please go to YouTube, hit the little bell icon, become a subscriber. We're very close to our magic number. Please go on Facebook and like us. If you like the show, please share with your friends. Share the links. Share the particular shows. Let everybody know about Crimes and Times. And as we continue to broadcast, please feel free to ask us questions and become involved in the show. I'm Michael Tabman. This is Crimes and Times. Thank you for listening. Good night.